Now let's welcome our guest for this hour, National Trial Attorney Michael Jaafar. Michael, let me start with the obvious question. And as I was watching this trial unfold, I couldn't decide what a jury was going to do. I just couldn't decide if they were going to buy her claim that it was self-defense, that he was in a warrior pose. Are you surprised by the manslaughter conviction or not?
I was a little bit surprised. I was very relieved that she wasn't convicted of the murder too. I was a little bit surprised. I felt like there was ample reasonable doubt that she did anything nefarious, right? Obviously, only two people know exactly what happened in that room, and one of them is dead, and the other one just got convicted. But to me, if you're gonna acquit Marcia Thompson, I think you had more reason to acquit Ashley Benefield than Marcia Thompson, right? Like, she was not a trained person. Her husband was a trained military man. Clearly he had rage problems. Clearly he had been a very menacing type of figure in her life. We saw that with the text messages that the prosecutor herself brought up, right? So, you know, and I had this gut feeling this entire case before she took the stand and after she took the stand that the jury just wouldn't like her, right? And it's just a gut feeling. Again, that's why I was relieved she wasn't convicted of the murder too, but I still was a little bit surprised that she was convicted at all, because at the end of the day, why else would she kill him? She would invite him to her house to help her move and then just murder him. Does she look like the type of person who would orchestrate a murder of the father of her first child? It just didn't fit to me, Judge Ashley. I was a little bit surprised, but kind of relieved at the same time that it wasn't the murder too.
Well, I would agree with you. Number one, I do think murder two, the evidence was not clear, clear enough for that. So I would agree with that piece. I think her likability does come into play. To your point, Marcia Thompson, I thought once she testified, was very sympathetic, very empathetic, a lot of history. But I also think the state leaned into the motive. And I think the other evidence the jury heard, and about the fact that she had done things to prevent him from seeing the daughter, and now was going to try to move to Maryland with the daughter, and who knows what he said to her prior to the shooting. Maybe he said something to incite her, to threaten her. We just don't know that. But I want to listen together. To your point, let's take a little bit of a listen. She did testify in her own defense. Let's listen to some of her testimony together.
Doug was standing in the doorway. His face was red. Like the veins were bulging in his neck. The way he was looking at me, it didn't even look like Doug. His eyes were black.
Does he yell anything at you?
He said, "You're done."
And what does he do at that point?
I held the gun like in front of me, and I said, "Stop." And he like turned and he got into this like a fighting stance. I got low, and he started like moving his arms and his hands around. He was making these like jerking motions.
What were you expecting when you were holding the gun out in front of you and you told him to stop?
I thought when he saw it, he would leave.
Did he?
No.
At that point, Ashley, what are you thinking?
I thought he was gonna kill me.
Tell us what happens next.
He started coming towards me, and then he lunged at me, and I just started pulling the trigger.
Michael, I think it could be argued that it felt a little bit like she was acting, that it was too extreme. So maybe the jury didn't like her. This was the first time that he allegedly physically assaulted her. There was no history that we are aware of, nor that was brought into evidence. But let me ask you this, because the jury deliberated. And then after hours of deliberating, they came back and said, we can't reach a verdict. And then they went back to deliberate some more, and it was well less than an hour that they came back with this verdict. Does that tell you anything about what might have been going on? I was surprised. I said, maybe the holdout said, all right, forget it. Let's just go with manslaughter.
Yeah, and it was late at night. Her testimony was a little bit cringy, but I've seen people cry in a people cry differently, right? Some people look really, really horrendous when they cry, but it's genuine. Some people look like you would typically imagine you would look like when you cry. I was also, like everybody else, looking at her testimony and cringing a little bit, but really trying to gauge, credibility. The jury was in the room with her; they saw it. But I felt like her and her defense put on enough ample evidence that she was in fear for her life. Again, she left him and she moved to Florida. Obviously not because, there was no evidence that she was just a bad seed who was just trying to separate him. I mean, she married an older man for a reason. She got pregnant with an older man for a reason, because presumably she was in that position. And so if you're the jury and you're looking at it and you're thinking, I mean, why was she all of a sudden, he had not abused her before that, but she never murdered anybody before that, right? This is a first for both of them, and they were both in a weird situation. And I could see how a person as diminutive as her, as light and small in stature as her, feeling like she needed a gun to defend herself. I mean, again, just the text messages that were shown in court that he would send her just showed him to be just a very, 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 unhinged type of person. And he would say things that I could see how it led itself to that event where she'd point a gun at her. Again, maybe she killed him intentionally. Maybe the jury got it right. But when a jury stays deliberating for so many hours and then comes, look, I think it was in 30 minutes after they went back and they came back with a verdict, it just, I think they got it right. I'm not gonna step on their logic. It surprised me a little bit.
But I do agree with you. Murder, I think most of us who have been watching it, following, felt like that, based on the evidence, would not have been an appropriate conviction. So I want to bring in at this time National Trial Attorney Michael Jaafar. Michael, I think that was a very smart question on cross about, hey, if you can't determine the speed, the force, then you can't determine how fast that person, i.e. the victim, was coming when he fell on the knife, which is basically the story of the defendant in this case.
Yeah, absolutely. Look, stab wounds are different than gun wounds, right? Gun wounds, you don't have this line of questioning. With stab wounds, obviously you have to go through the physics and the mechanics of a knife or a stab. And so I'm pretty sure the defense are going to be able to establish that there's nothing conclusive that shows whether or not these were defensive wounds or non-defensive wounds from the testimony of this examiner. And I don't think it's going to be possible when you have a stab wound to the heart, because at the end of the day, that passed through ribs, that passed through a lot. And so they're going to be able to come in and say, look, there's no way you can penetrate a rib cage by just simply walking up to somebody and just surprising them. There has to be some sort of an attack. They're going to put it in the jury's mind. They're going to create the specter of reasonable doubt as to whether or not she just acted nefariously without any type of prompting by the victim. And so I think this defense attorney, by the way, I've seen him cross-examine several witnesses here, the first responders. He does an excellent job. He's very efficient. So I'm very confident that when they come back from the lunch and he continues his cross-examination, I think he's going to leave that jury with a puddle of reasonable doubt in their mind.
So if a jury doesn't know, can't say from the evidence exactly what happened, is it then the credibility of the defendant that helps them make their decision? Because I feel like that's what it boils down to in so many of these cases when self-defense is claimed.
All of these self-defense cases, especially battered wife cases, I struggle to remember the case where the spouse did not take the stand. I'm sure it happens a lot, but you have to have, the spouse has to take the stand to tell the jury what happened. She has to bring them into it, and especially after this exact witness right now, that jury hates this woman. Because whether or not they're defensive wounds or not, the wounds were very grotesque, and the pictures that the jury saw were very grotesque. So the defense is going to have to bring in their client to make the jury, to bring them back from their hatred of their client, of Christine Ritchie.
All right, let's do this. We've gotten through their lunch break. Let's get you back into court so you don't miss a moment. The Commonwealth has rested. No more evidence are they going to present in their case in chief. Michael Jaafar, I'm going to push back. I know that you said, yes, the spouse has to testify. They have to tell their story. But if counsel knows that the spouse might be non-sympathetic, or if there are things like, well, the defendant had a fat lip and injuries, according to one of the state's witnesses, and that may open the door for her to be asked how to get those. All of those things, I think, mean this particular spouse may or may not testify. But I think there's a chance she might not. We don't know if she's going to or not.
I think she has to testify because that last witness made the jury. I mean, I hate that. I'm disgusted by the evidence. And we didn't see the photos. The jury saw the photos, right? But yeah, I mean, obviously she's a wild card. But at the end of the day, she's on trial for her life. I think that she has to because even her daughter who was at the house didn't actually witness what happened. Only 2 people know what happened, and one of them is dead. The other person's in the courtroom. I just don't see how, as a defense attorney, I mean, we've seen people not even attend their own trial. So obviously it's very possible that we don't see her take the stand, but we don't know why. We've seen people, they don't even attend their own trial. They stay in the cell. So she might tell her attorney, I don't want to testify. But to answer your question, Judge Ashley, do I believe that it's smart for her to testify? Yeah, I mean, she doesn't have a criminal. She's not like, she didn't go to jail for larceny. It's not that she has crimes of moral turpitude in her background. She can be impeached on what she says, but she's had years now to prepare for this. So I think that she would have been prepared by now, and she has to show the jury. She can't just sit mute, in my opinion, and get acquitted.
Yeah, and, she can convince, arguably, at least one juror by taking that stand. The other thing I have to note is the shortness of breath, the rapid heart rate that this victim experienced. All right, thank you, Michael Jaafar, for joining me this hour.